This video contains excerpts from an online workshop that the U.S. Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by U.S. Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
We're going to talk about the American system of evidence and its preference for and almost requirement for evidence in a case, in a criminal case, to come through witnesses, to come from witnesses who had firsthand knowledge about the facts of the case. In other words, a witness who was an eyewitness, or from a witness who was an ear witness, someone who may not have seen whatever it was, but had heard direct evidence about it. That's the preference. And really more than the preference, that is nearly the demand in American criminal courtrooms based on evidence law. In other words, the rules frown on evidence being admitted that is not direct evidence from a witness who observed the facts firsthand or who heard something about the facts firsthand. Now, today, we're talking about one of the largest exceptions to that rule, which is there are times in cases, frequently, in fact, where there are witnesses who have or may have helpful knowledge about the facts of a case, but who were not there. They were not eyewitnesses, or they were not ear witnesses. They don't have firsthand knowledge. And nonetheless, the rules of evidence allow these witnesses to testify. And we're talking about expert witnesses. But let me just give you two very, very quick examples. Take a homicide case, a murder, for instance, where the defendant in the case is being charged with a homicide, but there were no witnesses. And one of the main pieces of evidence, however, are fingerprints recovered from the scene of the murder. No eyewitnesses, no ear witnesses. In this little hypothetical, there must be a motive, which I won't get into, whatever that may be. But you would need a witness to testify about those fingerprints. That witness, again, not an eyewitness, not an ear witness, but instead it would be an expert witness who could help the jury understand what the fingerprints mean. Another example, not criminal, a car accident where, again, no eyewitnesses other than the driver, no ear witnesses. The driver says that he was traveling the speed limit. The state, the government says no, the driver was driving an excess rate of speed and was driving recklessly. The one piece of evidence that might be helpful is the length of the skid mark at the scene. The length of that skid mark might be able to tell you the rate of speed at which the driver was driving right before he had this accident. Again, no eyewitness is going to tell you that. No ear witness is going to tell you that. But an expert witness could come in and talk about the weight of the car, the condition of the roadway, and the length of the skid mark, and deduce from that, using physics and whatever else, how fast that car was traveling. There are really two leading cases that govern the admissibility of expert testimony in the United States. The first is the Frye standard. That happens to be an older case from the 1920s that has become, in almost every jurisdiction, outdated. But nonetheless, Chris and I are going to talk about it because it'll help explain the action of expert evidence so that we can understand it better. The Daubert standard is the more current standard. The rules of evidence in the United States have codified the rules of admissibility on expert witnesses, and that rule is Rule 702. Let's take that car crash hypothetical that I did. And let's say that there was an eyewitness to it. And that eyewitness says, I saw the car, it was traveling through the intersection, and it appeared to me to be going fast, faster than the speed limit. But what the eyewitness couldn't offer is an opinion based in his or her expertise about how fast that car may have been going. And that is one of the critical distinctions between what we call a lay witness and an expert. The expert could come in, based on my hypothetical about the skid marks, and could say, based on my expertise, I have an expert opinion about how fast that car was going. And in my opinion, that car was going 72 miles an hour, whatever it is. And that opinion is not something that lay witnesses, regular witnesses, the eyewitness that I mentioned, can offer. One of the first things we need to realize is that, as we have up here, expert witnesses are granted special status by courts. We are making a distinction between lay witnesses and eyewitnesses. And the distinction is made in the rules. And the rules acknowledge the difference. And expert witnesses just can't walk into the courtroom and start testifying. There's a series of requirements that need to be met before their testimony is admitted. One of the key distinctions is that the opinion, the evidence that the expert is presented to offer has to be beyond the ken of the average juror. That word ken is, it's an unusual-ish word, I think, in English. You don't hear it used very often. And it's a legal term of art now. And essentially what it means is that we prefer that fact finders, whether they're jurors or a judge, decide the issue on the evidence presented in court in addition to a juror or the group of jurors' own life experience. In other words, jurors can use their common sense. They can use logic to determine a fact at issue in a case. Things that are within their ken, within their experience, within their common sense. But there are many things, some very, very complicated, sometimes things not so complicated, which fall outside of a typical juror's experience, that they wouldn't have gained, life experience in determining. And those, generally speaking, are the areas that expert witnesses are allowed to come in and offer opinion testimony about. A couple of other distinctions, which I think we hope will guide our understanding about expert witnesses. Expert witnesses may consider a number of things informing their opinions, and they can offer their opinion even if aspects of it are based on hearsay. In other words, expert witnesses, they're not eyewitnesses, they're not ear witnesses. Almost all of the information that they would have to offer their expert opinion is going to come from sources outside of their own experience. In other words, they are almost by definition basing their expert opinion on hearsay, what they've heard or seen from other people who have information about the case, including information in their own subject matter area, in their own area of expertise. One of the other distinctions about expert witnesses is that they can offer opinion testimony, something that lay witnesses cannot do. They can also be asked about and offer hypotheticals. So if a lay witness was testifying, a lay witness couldn't be asked, well, what if the car had been traveling 40 miles an hour? Would you have expected it to, skid that much or crash with that much force? You can't ask lay witnesses that question. Lay witnesses can't answer it. On the other hand, an expert witness in car crashes or an expert witness in fingerprint analysis could be asked those types of hypotheticals. And if the information falls within their area of expertise, they could offer an answer based in expert opinion. The last example is, and at least the way I conceive of this, is expert witnesses, not always, but frequently testify to industry standards. Go back to the second on the list here, beyond the ken of the average juror. Most jurors don't know what the industry standard is for car tires, or for safe rates of speed, or for fingerprint matching. I mean, how many ridges or points on a fingerprint collected at a crime scene have to be available in order to make a match? Lay jurors don't know that typically. And you can imagine, industry standards go on and on and on. They're in as many industries as there are. But experts in particular areas may have an expertise in a particular industry, and they can be brought in as expert witnesses to testify about whether the baby's crib exceeded or fell short of industry standards, in a case where the fact finder may be trying to decide whether the manufacturer was negligent or not. In a lot of criminal cases, which is sort of our focus here, I think it's fair to say, Chris may take issue with this, but I think it's fair to say that industry standards don't come up terribly much in criminal cases. It seems to me typically they come up more often in civil cases, because I think it's a good way to distinguish between lay jurors and experts. These are a list of things that are typically expert witnesses will testify about.
I would just add, in terms of industry standards, because I was looking at where we're heading on this, and one of the kind of issues that is just beneath the surface of all of what we're talking about is the difference between scientific evidence and kind of other types of expert witness testimony. And so we're going to try to focus on the scientific aspect of this primarily, but we'll also talk a little bit about what expert witness testimony that is non-scientific, technical expertise is. So in terms of industry standards, if you're getting a non-scientist to talk about industry standards, it could be something like a police officer talking about drug packaging, right? Because he's an expert or she's an expert because they've encountered, drug packaging as a result of their police work for 20 years, right? And say that that's the way that cocaine is typically packaged, or that's paraphernalia for cocaine. I'm an expert in this area. So that's just another way that industry standards get in through expert witness testimony. So there were no really regular rules around the admission of expert witness testimony before the Frye case in 1927. It had been a hodgepodge of different types of decisions. And then there was a challenge to the admissibility of a very, very early iteration of what today would be called the polygraph test or a lie detector test. And the challenge was in the DC Court of Appeals, which is still today, a very influential court. And what happened in Frye is that the court took a look at this whiz-bang technology that was being touted as an ability to tell if somebody was lying. And the court was deeply skeptical of this technology, the ability to tell if somebody was lying or not. And what it found was, so there's a reason that I highlighted the psychological and physiological authorities there, because that'll become important in a minute. And this is an interpretation of this 1927 case in 2006 by the New York State High Court. Frye, this first decision, became a landmark decision. It's not a Supreme Court case, but it became the standard for most states for the introduction of expert witness testimony. And what happened between 1927 and 2006 is that courts around the country interpreted the Frye decision to kind of come up with some general principles as to applying Frye to either include or exclude scientific testimony. And so what the test became known as is the general acceptance test. And what that has a couple of different elements to it. And one was that it was supposed to be novel. In other words, that it would have to be something new. So, for us, at the Innocence Project, where we're concerned about techniques that were once admissible, but have been discredited through the progress of science, you couldn't even really challenge the scientific testimony at issue through Frye because it has to be novel, and these techniques aren't novel anymore, right? So theoretically, you cannot challenge them. So there are also general acceptance means that the court itself was not charged with basically learning the science. What the idea became was that judges, they're not scientists, they're not mathematicians, they're not really in a great position to judge scientific validity and reliability issues. What they say was it's the scientific community that is in the position to judge whether the science is valid or reliable. So what they said is that if it's a new technique, you look to the scientific community and see whether or not within that community it's gained general acceptance, right? And so in other words, it could be a minority point of view would not be admissible, right? So because it hadn't gained general acceptance yet. So the idea was that courts would do essentially a nose counting, they would define the community, which we'll talk about in 1 second, and to say is this a generally accepted forensic or scientific technique? Now, how that community became defined, the relevant scientific community, and the reason that I chose this line, because this is the New York court, it says the scientific community generally. Now that's kind of a generous use of that phrase because that means basically any scientist, right? But most courts called it the relevant scientific community. And that makes sense, but how you define the relevant community is basically outcome determinative as to whether or not it's going to be admissible, right? So because if you define the community, let's take something like fingerprints, right? Fingerprints, if you define the scientific community as fingerprint examiners, the question as to whether or not it's generally accepted within that community is a foregone conclusion, right? They make their living doing fingerprints, right? So of course, they're going to tell you that the science is generally accepted. And they're going to argue that they're the scientific community, that it should be them that is the arbiter. So what that leaves out are people like statisticians, right? And a statistician could tell you, well, you may believe that the fingerprints are unique, right? And particularly latent fingerprints, which only have, partial information. But as a statistician, I can tell you that you don't have the statistical foundation to make that claim, right? That's just your opinion, and that opinion is not valid based on science as we know it today. And that's true with all pattern matching techniques. Even DNA, we assume DNA is unique because we've done sufficiently robust studies that the law of statistics allows us to make that assumption. But even then, you don't say there could never be another one because we don't know that. So the idea that the problem, depending on the way it's interpreted, is that only novel testimony was challengeable, and courts began to look to forensic experts and define the experts themselves as a scientific community. Courts had, for 50 years, and Tucker and I wrote an article that talked about some of this, had defined the relevant scientific community as the bite mark experts, the dentists themselves, right? And they had invented the whole thing. They'd never done any foundational research about it at all, but it was accepted widely. So we have, in strategic litigation in particular, been litigating in courts in states that still have the Frye standard to say that no, the scientific community includes people like cognitive neuroscientists that can talk about bias, statisticians, physicists, you can go on and on with like the different techniques. So we're trying to get more expansive rulings, and Tucker is correct in that the Frye standard is outdated. But you look at the states that still use the Frye standard, it's some of the most populous states in the country. So it's still a very significant standard, sadly, I think, in many ways.
It seems like the theory of the court in the Frye case back in the 1920s was that science only moves in one direction, that science only moves in the direction of progress. So when new scientific methods are introduced, they have to go through this vetting process meet this threshold standard. But once a court accepts that branch of science, it doesn't have to examine that anymore, because the theory is scientific progress only moves forward and doesn't review previously accepted scientific conclusions. Is that right?
It's exactly right. And what really the work of the Innocence Project and related, organizations demonstrated, beginning in the late 90s through DNA exonerations, is that all these forensic techniques that had been accepted by courts for a very long time, had passed through the Frye test, were actually not valid. They were getting it wrong. They were falsely convicting people for crimes that they did not commit. So the idea that science can also, I think it still could be considered progress. It's just saying, well, what we knew before, we no longer believe. So there's a recent decision in the New York State Court of Appeals, which in New York is the state, essentially the Supreme Court, the highest court in the state, that we and two other criminal justice reform organizations, we submitted a bunch of briefing and litigated a lot around this issue. And we got a better interpretation of the Frye standard in New York. So, and we also litigated the same issue in Pennsylvania. And now what they're saying, they pointed to things like bite marks and hair comparison evidence and acknowledged that some techniques may not be novel, but are subject to challenge. And they also talked about defining the relevant scientific community as not just the self-interested experts, and pointed to the Office of the Chief Medical Examiner in New York City, which is the most influential medical examiner's office in the country, that had been using a statistical tool to analyze tiny amounts of DNA that they had insisted for years that they had internally validated, but was in fact not reliable, not valid, and finally taken offline. But every court in the city and the state had deferred to the OCME, defined them as the community that was in charge of this particular technique, and just never actually examined it. It took a federal court to order the OCME to turn over that data before we learned that, oh, they were wrong, right? So it's really, really important how in FRE jurisdictions, if we don't consider people who don't have any stake in a particular technique, we have to have outside critics, basically. You know what I mean? Is that people who are going to give it a fair read and a critical examination.
Frye was a case from the 1920s. Rule 702, as we said, which ultimately codified the admissibility in the rules surrounding expert testimony, didn't get to us until the 1990s. If you were to look at Frye, if we're to read Frye in a vacuum, Frye seems like not a bad decision. Kind of makes sense. Yeah, we want to admit expert testimony only if the general scientific community agrees that it's legitimate. That sounds good on the surface. That sounds like a rule that makes some sense. But after we get to Daubert in the 1990s, then I think we can really begin to see a point that Ira brought up and that Chris elaborated on, which is, wait a minute. Science is not a static field. It's dynamic. There are developments constantly within the field. And the general acceptance test that Frye has another side to it. And that side can be limiting, can be problematic, can be almost anti-science. And that's what we'll get to.
Every state has a different interpretation of its own evidentiary rules. You know, so there are nuances in every state to basically every evidentiary rule. It's state Supreme Courts that interpret the evidence. Usually, I mean, there are some that are done by, you know, study groups. Every state is a little bit different. So New York standard, I put that up because it was available. It was an interpretation, a more modern interpretation of Frye. It changed it in the sense, the reason that I used it was two things, is that I thought that it was important to show that there were some states that say that it's the scientific community generally, and that was one time that the court had said that. There were other times where it said the relevant community, you know what I mean, but that was a more recent pronouncement. So we used that particular case a lot when we were talking about that to make the argument that it's not the practitioners themselves that define the community. When it's generally accepted as reliable it's kind of vague, you know what I mean? What reliability in science, you know, basically means that it can be repeated, right? And that two experts, you know, analyzing the same evidence will come to the same conclusions, you know, under the same circumstances. So that produces reliable results, right? You know, and so that extra results is an important piece of language, because if it's generally accepted as reliable, doesn't really it can mean a lot of different things.
This gets incredibly complex very fast, because as I understand the Parker case, and I don't practice in New York, I know of it. The ultimate opinion that the expert was offering was really not the issue. There was general agreement that these chemicals could cause these problems. Seemed like that was something that experts could and had testified about over and over again in cases dealing with, I think it was benzene, exposure to gas. But there was a threshold question, which was, Well, how much gas or benzene, if I'm correct, was this plaintiff actually exposed to? So in other words, before we get to the ultimate opinion, which is that this is dangerous, you can get cancer from exposure to benzene, we need to know whether or not and how much this plaintiff had been exposed to benzene. That was and the plaintiffs, if I recall, either didn't present any or didn't present enough evidence of the plaintiff's exposure. So at least as I hear your question, or at least think about it, that's sort of my point, that this becomes complicated. Yes, it's generally the case that experts have been allowed to talk about the dangers of benzene, but we're not just going to necessarily admit this particular expert to talk about the dangers of benzene unless this expert or other witnesses can first demonstrate that the plaintiff had been exposed for some period of time, right, that would have made it dangerous. Even though the Frye decision was a 1920s decision, every state, including the states that have continued with the Frye standard, have developed the standard over the last 7 decades. So in some sense, to say that it's the same Frye standard that came out of the DC courts is not exactly accurate. States have used that standard and applied it to developing scientific disciplines in order to, for lack of a better description, keep it up to date.
A really good example of this, if you look at Florida or you look at Georgia, and their standards for expert witness testimony have evolved over the last 10 years. And really, if you think about whose interests are served by better science being used in court, right? It's like, and this is true with so many things. If you follow the money, you're probably going to get your answer. And so when you have large corporations that are routinely sued by plaintiffs' corporations sometimes for good reasons, sometimes for, less good reasons, is that what those corporations want is to attack the small guy, right? The plaintiff's experts are often depicted as the small guy, right? Who have like this one expert that's going to say that that this big bad chemical company caused the birth defects of my child. I'm bringing, I don't have the resources that Dow Pharmaceutical, which was the defendant in the Daubert case, has to fight that off. So it benefits large people that are sued a lot to exclude evidence that suggests that they're liable for whatever kind of tort is being charged, right? So there was an industry push to enhance the rules of evidence because there was this spike in civil litigation in the 70s, 80s in particular, that a lot of major corporations got bankrupt by plaintiffs' attorneys that were filing lawsuits around the country. If you look at like the silicone breast implants, or that kind of thing, that a lot of like bad science was used that brought down companies that were actually not committing torts. So that standard, so if you look at Georgia had been controlled by Democrats who tend to that's a complicated history in Georgia around this, but the idea is that Democrats tend to favor the small guy, the plaintiff's lawyers, right? And not the corporations. So when a Republican was elected to the Georgia governorship for the first time in a century, first thing that the corporate bar, basically started lobbying for was to change the evidentiary standard from this incredibly lax standard they have in Georgia to bring in Daubert to protect corporate defendants and corporate interests from the lawsuits. And so this happens, and then people aren't usually thinking about the impact that it has in criminal law. right? Because it's the same standard, you know, and on both sides. And like the money always leads than the criminal side. In Georgia, just to tell you a story that's really outrageous and that we're doing a lot, and it kind of speaks volumes about what we're talking about here in terms of the justice aspect of expert witness testimony, is that when the Georgia Republican, Sonny Perdue, who's now the Interior Secretary, was elected governor, they started this movement to change the rule to Daubert. But Georgia had this thing that was even more permissible than Frye before that. And the prosecutors came in and they said, fine, you can change the expert witness rule for civil, for the money matters, but we like our standard over here for criminal matters. And so as a result, Georgia has two rules, right? They have one for civil and they have one for criminal. And so in my mind, the reason that some states have it and some states don't is largely based on corporate America and less about some of the other issues that we're talking about. You could find people that would disagree with me, certainly, but I think that there's a real element of that.
I just want to add there some foundational issues that I'm sure you are aware of, but sometimes it's easy to forget that in the United States, because of our federal system, on some issues, every state gets to decide their own rules. You know, we don't have a national system the way China does, or a unitary system. So how to define crimes and how to define evidence is left up to each state. We don't have to have a uniform rule. So that means states have the ability to adopt whatever rule they think is appropriate. And then, so we don't necessarily have uniformity. But the other thing I want to mention, it's sort of in the background of our discussion, but we haven't talked about it directly yet, is how powerful these rules are. As Chris mentioned, if you make the threshold very high, that would exclude certain types of evidence. The jury would never get to hear that evidence. And again, our evidence rules are mostly written for civil and criminal cases, and in general, Georgia is the exception. We wouldn't think that the standards for admissibility on expert testimony should be different for criminal cases or civil cases. The real issue is how do you define a rule that allows reliable scientific evidence in, but excludes unreliable scientific evidence. That should be the same for criminal and civil. But because the interests are different, it's possible, although it's exceptional, to have different standards. You know, I think your question kind of assumes that everyone will just adopt the best rule, however you define the best rule. But our system allows different people to define whatever the best rule is differently, depending on the circumstances.
The Daubert case arose in the early 1990s. Oftentimes, rules, and particularly around the admissibility of expert testimony, are driven by the kind of case that the court is presented with. In other words, it's not necessarily the philosophical underpinnings of how we understand science or how science and law intersect, but really it's just about often the facts of the case. Are they good facts or bad facts for the plaintiff or the defendant that drives the court? And Daubert is a great example. In Daubert, the issue was this drug called Bendectin, which pregnant women had been taking for years. It was an anti-nausea drug. But there was also a potential problem with the drug, which was that some women when they delivered their children, were delivering children with birth defects. Oftentimes, not always, but oftentimes related to limbs, like a deformed hand or leg. And there was thought that perhaps bendectin wasn't as safe as Dow Chemical and other pharmaceutical companies had said that it was. And so in Daubert, the plaintiffs sued the chemical company that made bendectin and claimed that the drug was dangerous, that it was causing birth defects. The plaintiffs, though, lost all the way up to the U.S. Supreme Court. And the reason they lost was because of the Frye standard. They could not get a court to consider the opinions of their experts. Why? Because the opinion of their experts was a minority opinion. It was not generally accepted, which was the Frye rule. And I'm going to read briefly from Daubert to give you an example of what we're talking about. The defendants in the case had an expert who had reviewed all the literature on bendectin, which consisted of more than 30 published articles involving 130,000 patients. And none of those studies had found bendectin to be capable of causing malformations in fetuses. In other words, bendectin, at least according to this expert and all the data that the expert had looked at, bendectin was safe. The plaintiffs in the case didn't necessarily take issue with the published record, but they had 8 experts of their own, all of whom also had impressive credentials. And their experts had concluded that bendectin could cause birth defects. Their conclusions weren't based, obviously, on the studies that the defendants were using. Their evidence was based on, their opinion was based on in vitro, test tube, and live animal studies, which showed a link between bendectin and malformations in children. What's interesting about this case and where I started out is the facts are really compelling. You know, children were being born with significant birth defects, and there was at least some legitimate evidence that bendectin was the cause. Was it the majority opinion? No, it was not. And as Chris said, you know, consider where the majority opinion was coming from. It was coming from big pharmaceutical companies that had hired experts to study their product to determine if their product was safe. Their product was making them a ton of money. And up against that was this minority opinion. But those are compelling facts. You know, we're talking about children born with birth defects. As I said, the plaintiffs lost all the way up to the Supreme Court. By the time the case got to the Supreme Court, though, the federal rules of evidence, Rule 702, had been adopted. And that rule, as we're going to get to in a minute, changed the landscape of the admissibility of expert testimony. What the Supreme Court did in Daubert, though, was agree essentially with the adoption of Rule 702 and then determine that Rule 702 would have allowed for the plaintiffs to introduce the minority expert opinion in their case. It didn't mean they won, because a fact finder would have to determine, you know, which side it credited, the defendants' experts, being the pharmaceutical company, or the minority experts for the plaintiffs. But what Daubert did do is said, we're going to change the general acceptance Frye test. And we're going to, and this, let me pause here. This is the way I explain Daubert to my students. I think Chris and I interpret it or talk about it slightly differently. But the way I think about it is the U.S. Supreme Court in Daubert expanded the ability of courts to admit expert testimony. In other words, no longer were courts only admitting generally accepted expert opinion, which is what Frye said. Courts were now saying, no, we will broaden the standards for admissibility to include even minority positions which may not yet be generally accepted. To go back to something Ira said, because science is dynamic, it moves forward. The minority study today, the minority opinion today, may be tomorrow's majority opinion. That's how science works oftentimes. And we're not going to preclude that minority opinion from being considered by the fact finder. In that way, Daubert, at least the way I conceive of it, expanded the ability for the admissibility of expert testimony. However, the court also, consistent with Rule 702, said, but wait a minute, there are standards. It's not a free-for-all. It's not any opinion, no matter what comes in. No. There are standards. And if you look at the slide, there are 5 standards listed here, but these standards are not necessarily exhaustive. And I think one of the things you'll sort of notice about them, intuit about them, is in some ways, they are the components of what we understand to be sound science. So, majority opinions can come in, minority expert opinions come in, but if and only if the theory or technique in question has been tested, whether it has been subjected to peer review and publication, whether we know its error rate, whether we know and can articulate the existence of controlled standards for how it was tested, and whether it has attracted widespread acceptance within a relevant scientific community, something Chris has already talked about. These, again, are a non-exhaustive list of standards, and the reason I'm non-exhaustive is because A, they're non-exhaustive, but B, various disciplines have different standards. But generally speaking, these are sort of the touchstones of whether or not a particular discipline or expert's opinion is deemed trustworthy enough, reliable enough to be admitted consistent with Rule 702 in Daubert. So I hope my conception of it anyway is A, not completely wrong, I don't think it is, but B, that it makes some sense, which is we've moved away from Frye to a broader acceptance, and to in large part driven, I think, by the compelling facts of Daubert. Birth defects in fetuses, in newborns. That's compelling. And the court felt like, we should admit this type of evidence, not because the plaintiff is necessarily going to win, is going to prevail, but because fact finders should at least be able to hear and consider this minority opinion, which meets Rule 702 in Daubert, meets some of those standards, or all of them.
I don't disagree with I do disagree actually with Tucker, but there's plenty of support for Tucker's interpretation of Daubert in terms of it being more accepting of a broader range of purportedly scientific opinions. And certainly it says that in the opinion itself, that, and you'll see a lot of courts seizing on the flexibility language of the standard to admit almost anything. So in my view, and perhaps a minority view amongst legal scholars, is that the standard itself is, if it's rigorously applied, or even, with fidelity to real science applied, it would exclude much of what actually gets into court, as a practical matter, because this is very, like, judges were before supposed to be deferring to the scientific community. And what this opinion changed was that the judges were now acting as gatekeepers, right? So it was their role to basically learn the science, right? To know whether or not that the technique had been tested, and whether or not, the peer review and its error rates and all of these elements. The court charged the courts with excluding that type of evidence. And that hadn't been the case before. It had been deferring to what scientists says. And a lot of mischief could be made with that standard, because how you define the relevant community, as we talked about before. So I think that Tucker is correct. And certainly in the way that the opinion reads, but as a practical matter, I think that the standard is actually a much better standard. It just needs to be applied in a rigorous way. The Daubert opinion was really three opinions. There was the Daubert opinion, there was Kumho Tire, and there was a case called General Electric v. Joyner. And basically these trio of cases changed the federal landscape and then ultimately state landscape on the introduction of scientific expert testimony and just regular expert testimony. So Kumho Tire was the case that followed Daubert to the Supreme Court. And that was technical expertise about, I think it was the air pressure in a particular tire, was the recommend. I can't remember exactly what it was about the tire at issue, but the expert testimony wasn't necessarily scientific testimony, right? So it's very, very difficult to say what's scientific experts, or what's scientific and what's just technical expertise, right? Is crime scene reconstruction, is that scientific evidence or not, right? Is it, it's very, very hard to say, right? And then there's always been this kind of exception, through the case law for a lot of the techniques that have been introduced as scientific evidence, but have not been subject to really any standards, essentially because the courts have looked at those techniques like fingerprints and bite marks and tire tread evidence and said that this is really not complicated stuff. This isn't the kind of science we are talking about, and you don't have to know all these error rates and all the rest for Daubert. They've kind of excluded that from real scrutiny, some of the worst, purportedly scientific evidence that's been introduced. Kumho Tire says that we're not going to make this distinction, and that between science and technical expertise, the same list of factors, the same non-exhaustive list of factors that we listed in Daubert are relevant when you're talking about just any expert witness testimony. You're going to have to be flexible with the way that you judge whether that's sufficiently reliable to be introduced in court. But this applies to non-scientific expert witness testimony as well. And I put that there because, this distinction, I think, is still playing out in American courts and still not getting it right in many circumstances. But theoretically, Kumho Tire should preclude, or at least create a more of a barrier to entry for some of these techniques that can't pronounce an error rate, that haven't been tested, that haven't been subject to real peer review, but the courts haven't been imposing it that way. So the third case in the trilogy is basically setting the standard for an erroneous admission of expert witness testimony. So if somebody gets convicted or loses a civil judgment and they say that they're appealing that judgment, the court said that that's an abuse of discretion standard, right? So the only way that you can get the judgment reversed is if that the court finds that there was an abuse of discretion for admitting that evidence, which is a very high bar to get anything overturned. So it really made the judgment at the trial level really, it's not going to be overturned unless it's really outrageous. So those three cases all set the standard. And just to be clear is that when the Supreme Court decided this, they have no authority over the state courts in terms of, or states at all, in terms of their evidentiary standards. The only thing that they could say was that this is for federal courts, and then it's up to Congress to legislate, federal rules of evidence. And those only apply in federal court. Now we're going to talk a little bit later about the influence of that in state courts, but just to be clear, we're talking about two separate systems, federal and state. And in federal court, all this is the law of the land. States can take what parts of it they want, what parts of it they don't want.
This is Rule 702, and it's worth just spending a minute on. A witness who's qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion. This is what Ira brought up very early on in the presentation, or otherwise if. And then the criteria are itemized below. A, that opinion has to help the trier of fact understand the evidence or determine a fact in issue. The testimony is based on sufficient facts or data. It's the product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. I think Chris and I agree ultimately on what Daubert means in 702. My point was, the minority opinion in Daubert, the plaintiff's expert who was saying, we've done a bunch of studies and it looks like bendectin is potentially dangerous. That was a compelling opinion, as I've said, for children in this case. And we ought not, the thinking goes, exclude minority opinions just because they haven't gained a majority foothold. Because as we've talked about, minority opinions oftentimes are tomorrow's majority scientific thinking. We ought to, in certain circumstances, allow those opinions to come in. And that way the gate is broadened. But here's really where Chris and I agree. It's not just that the doors to the courthouse were broadened, were opened more widely under Daubert. There's also the second half of that story, which is if courts were to follow rigorously the criteria set forth in Daubert and codified, articulated here in Rule 702, it might well be the case that fewer disciplines were getting into court, not more, because when 702 is followed, the criteria in Daubert is followed, it may well turn out that a lot of scientific disciplines, which had regularly been admitted into courts consistent with Frye, would not actually meet the standards of Rule 702. Does that make sense? So there, at least in my mind, there was a broadening because we're considering the admissibility of minority opinions. On the other hand, if we were to step back and really take a close look, particularly at traditional, long accepted scientific disciplines, if we were to step back and do that, many of them would actually not meet the standards set out in 702 and Daubert, and they would no longer be admissible.
So I would just say that the way that I think of 702 as it relates to Daubert, which can be confusing, is that if you look at C, the testimony is a product of reliable principles and methods. Basically, that's science, is the factors that are listed in Daubert will tell you that you're dealing with a reliable principle and method if you are applying the Daubert factors and judging that particular technique. So they relate in that sense. And the advisory committee notes, I think, also say that. And then if you go down to D, there reliably applied means that you can have a forensic technique or some other basically valid scientific discipline, but that it was applied in an unreliable way. Like DNA, for example, that's contaminated, right, is a really easy example. And so it would be excluded, even though the discipline itself is, obviously very reliable. To the extent that folks are interested in the way this is played out in state courts, Professor Brandon Garrett and I wrote an article called The Myth of the Reliability Test that talks about the failure of the courts really to apply Rule 702 in a meaningful way. I had this slide, we put the slide together to show how influential the federal government's rules are in state courts. And it's, as it says, is 38 states have basically adopted this rule. And what's interesting as far as wrongful convictions go is that overwhelmingly, I think there's one or two wrongful convictions in federal court. Most of them are in state court because that's where violent crime is prosecuted. And all of these techniques that we know have resulted in wrongful convictions have nonetheless sailed through these purported evidentiary standards. So they don't have real teeth because they're not rigorously applied. And that's particularly true on the criminal side. So my point with this slide was showing that this has been adopted. There's a lot of words devoted to this, but the reality is it's not working.